I'm attorney Sherry Stinson, and today I want to talk to you about the difference between a living will and a living trust. This is one of the most common questions I get in my office, and so I thought it might be helpful to talk a little bit about what the differences are, because leave it to lawyers to make things more confusing than they need to be, right? So, to understand the difference between the two, you need to understand that when we talk about estate planning, we're talking about two different things. We're talking about planning for death and planning for incapacity. So let's start with the living will. A living will is used to answer questions about end-of-life decisions. It expresses your wishes about what medical procedures you would want if you're terminally ill, if you're in an end-stage condition, or if you're in a persistent vegetative state. So, for example, do you want a ventilator? We're in COVID times right now. A lot of people are saying, no, I would never want to be on a ventilator. Do you want antibiotics? Do you want a blood transfusion? All these decisions that we take for granted that we might need to make are things that your living will could address. So, a living will often works in tandem with another document called a designation of healthcare surrogate. The easiest way to think about this is the difference between who and what about your medical decisions. So a living will says what you want, and a designation of healthcare surrogate says who you want to make those decisions for you if those decisions need to be made. Now, let's talk about a living trust. A living trust is a document that you create, and this document is meant to hold and manage your assets while you're alive, and then distribute those assets to whoever you want to receive them when you die. Now, a living trust and a living will sometimes do have an intersection because both of these documents can help manage your affairs if you're incapacitated. It's just that a living will manage the medical decisions for you, and a living trust could manage the finance decisions for you. Now, caution, caution, caution on a living trust, because one of the things that most often causes a trust to fail is when you don't do something called funding. Now, again, this is just a fancy lawyer word that means putting your assets into the trust so that the trust can actually manage them for you. Now, what most people don't realize or know is that if you fail to fund or basically connect the trust document that you've signed with the assets that you own, you've potentially created two problems for yourself. One problem is during your life if you're incapacitated, because now we have a trust, but we don't have someone who can manage everything that you own. The other issue that you can cause is when you die, if the trust isn't funded or connected, that you may end up requiring probate. And doing a revocable trust is one of the big reasons why people often do a trust to begin with instead of a will. Now, I want to give you a word of caution here. This is not something that you should try by yourself, or as they say on TV, don't try this at home, kids. Remember, you wouldn't do open heart surgery on your own. You're not going to open that kitchen drawer, pull out the knife and some vodka and say, this is a great idea. We don't do that. And the very same rule applies to estate planning. This is something that if you mess it up trying to do it yourself, you can really create a lot of problems, not only for yourself, but also for your family. And that defeats the point of trying to do this to begin with. If we can help you or answer any questions that you may have, give us a call. We will talk you through the process and help you figure out the very best thing for you so that you can protect not only yourself, but also your family. Thanks for watching.